The Supreme Court just made a major move in the fight over Missouri's Second Amendment Preservation Act, and while it looks like a setback on paper, what's happening behind the scenes could actually strengthen the state's case going forward. Let's break down what the court decided, what it means for Missouri's SAPA law, and why this story isn't over yet. The Supreme Court has officially denied emergency review in Missouri's challenge over its Second Amendment Preservation Act, often called SAPA. At first glance, that sounds like bad news. But in reality, it's part of a larger process that could still allow portions of Missouri's law to stand, and even open new legal pathways for states defending their own Second Amendment protections. This case has already been to the Supreme Court once before. The first time, the court refused to grant a stay that would have protected the law from a lower court's injunction. That earlier decision came down as an 8-1 ruling, with only Justice Clarence Thomas supporting Missouri's request. Now, after the case returned to the lower courts and then came back up for emergency review, the Supreme Court once again declined to intervene. But the reasoning behind that denial and the next steps tell us a lot more than the headlines suggest. Passed in 2021, Missouri's Second Amendment Preservation Act was one of the strongest state-level assertions of Second Amendment rights in recent years. The law basically says this: Missouri will not use state resources, money, manpower, or enforcement to support federal actions that the state believes violate the Second Amendment. It goes further by allowing Missouri citizens to sue any state or local official who helps federal agents enforce those disputed gun laws. In other words, the law empowers ordinary residents to hold their own government accountable if it helps enforce what the state sees as unconstitutional restrictions. To supporters, SAPA is a bold declaration of state sovereignty. To opponents, particularly the federal government under the Biden administration, it's an unlawful attempt to nullify federal law. When SAPA passed, the Biden DOJ immediately sued Missouri, arguing that the state had no authority to block cooperation with federal law enforcement. The district court sided with the Biden administration, striking down the entire law and issuing a statewide preliminary injunction, basically putting SAPA completely on hold. Missouri appealed to the Eighth Circuit Court of Appeals, asking for a temporary stay to keep the law active while the appeal played out. That request eventually led to the first Supreme Court emergency filing, which the court denied, as mentioned earlier. The Eighth Circuit later heard the case on an expedited schedule, but ultimately ruled against Missouri again, agreeing with the lower court that SAPA was unconstitutional. Following that loss, Missouri filed another emergency petition, this time while the case was still technically ongoing at the Eighth Circuit. That's important because the case hadn't reached a final ruling yet. The Supreme Court was being asked to step in midstream. Such interlocutory petitions are rarely granted, so it wasn't entirely surprising that the Supreme Court declined to take emergency action this time. But what happened around that decision and the response from the federal government adds an interesting twist. While this case started under the Biden DOJ, the new administration, led by President Trump, has taken over. The Trump DOJ has argued that parts of Missouri's law are invalid, but it also admitted that the previous judgments obtained by the Biden administration were too broad. Specifically, the Trump Department of Justice told the court that if the Supreme Court denied review, which it just did, they would narrow or release some of those prior judgments once the case returned to the district court. That's a significant development. It means portions of the injunction that completely blocked SAPA may now be lifted, allowing parts of the law to go into effect. Even though the Supreme Court denied emergency review, the case will now move back to the lower courts, where Missouri will continue fighting to preserve its SAPA law. Because the Trump administration has committed to scaling back the previous sweeping injunction, Missouri may get the chance to implement at least parts of the law and demonstrate how it actually functions in practice. That's key. Much of the federal government's argument so far has been based on theoretical harms, what they think might happen under SAPA. If Missouri can show the law working in real time without disrupting federal operations, it could reshape the case entirely when it eventually returns to higher courts. In short, the Supreme Court's denial doesn't kill the case. Missouri still has room to move forward. The federal government's stance is now more flexible under the Trump administration. This gives the state a new opportunity to defend its constitutional position, not just in principle, but in action. At the heart of this case is a constitutional question that could impact every state in the country. Can a state refuse argues to help enforce federal laws it believes violate the Second Amendment? Missouri says yes. The federal government says no, arguing that federal law is always supreme, even when it conflicts with a state's constitutional interpretation. If Missouri eventually wins, it could set a major precedent. Other states might pass similar preservation acts, creating a patchwork of pro-Second Amendment states that limit cooperation with federal gun restrictions. If Missouri loses, however, it could reaffirm the federal government's power to override state resistance, narrowing the practical reach of the Second Amendment at the state level. Here's what to expect in the coming months. The case goes back to the district court. The Trump DOJ is expected to release or narrow some of the prior judgments that blocked SAPA entirely. Missouri could begin implementing parts of its law. Depending on how enforcement plays out, new legal questions will arise, and that could lead to another appeal, potentially bringing the case back to the Eighth Circuit or even the Supreme Court later. This isn't the end. It's simply the next round in a long constitutional fight over state sovereignty and the Second Amendment. So while some headlines will say the Supreme Court rejected Missouri's SAPA law, the truth is far more nuanced. This denial doesn't close the book. It just turns the page. The next chapter will reveal whether the federal government keeps its word and whether Missouri's law can survive partial enforcement. We'll be watching every step of the way here on Guns Law Guide, breaking down each new court move and what it means for your rights as an American gun owner. Stay informed, stay responsible, and as always, stay free.